Sir? Oh no, but you're not on deathbed right now. Everybody's got problems, and sometimes people die or almost die, but they rebound. That's the way nature makes us. Where you assault them, it's like you slap me in the face. It has accountability. I'm not saying we need to put her in prison, but it's going to deferred is not going to. And Ms. Murphy, raise your right hand. Do you solemnly swear or affirm any statements you make during these hearings today in these two cases will be the truth, the whole truth, and nothing but the truth, so help you God? There's a first amended motion to revoke probation. I guess that's the most recent one filed here in 1187 of the case. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary, this states that on June 10th of this year, 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of assault on a public servant. Is that true? The First Amendment. This allegation alleges that you committed the offense of assault on a public servant on or about August 13th, 2024 in Jefferson County, Texas. And that allegation is represented in this new indictment for CR 1984. Do you understand that a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment, which is no less than 2 nor more than 10 years confinement. Knowing that, do you insist on pleading true today? I find you to plead true voluntarily. You understand and appreciate the consequences of pleading true. There's an agreement that's been reached. It says the sentence shall run concurrently. That's all it says. What is?
It should be 10 years deferred probation.
She's already on.
Oh, I'm sorry. We're just sending her to safety. On the new case, she's being put on 10 years deferred probation to run concurrently with this MTRP.
Hold on a second. Did you catch what just happened? The defendant is already on deferred probation for assaulting a public servant, and now she is admitted to committing the exact same offense again. In legal terms, that is one of the fastest ways to lose a judge's confidence. Deferred probation is often viewed as a second chance. But when the same behavior repeats itself, judges start asking a simple question. If the first warning did not work, why should there be a second one? Let me know in the comments. Should repeat offenders get another opportunity? Or is this where accountability has to take center stage?
And we're placing her back on probation and sending her to safety.
This motion.
She did commit another assault on a public servant.
Yeah, let me go through it. And then, so thereafter, on August 13th of 2024, as she's admitted, she committed another assault on a public servant while she's on deferred or unadjudicated probation for the same thing. And we're not changing her status from deferred. How many free ones do they get?
Just this one.
No. The public servants are protected by me. When you assault them, it's like you slap me in the face. It has accountability. I'm not saying we need to put her in prison, but it's going to deferred is not going to be allowed anymore. She's lost that opportunity because what's good for one's good for all. But a public servant, again, the same kind of thing. You knew we made a big deal about it and that it was forbidden. So yet go back and do it. I'm not going to do that. Now, I didn't say the idea at all, but it's going to have to maybe be evolved to a regular probation, maybe.
Excuse me.
Can it be?
And on the old case, it would just be safety and continue to defer on the old case.
Yeah, no, I'm not going to do that.
No, I'm talking about on the old case.
The old case, she was placed on deferred, and she's committed a crime while on deferred, an assaultive crime on a public servant. She doesn't stay on deferred.
So
that's just not the way I do it. She knew.
Mm-hmm.
She had been scolded the first time and yet went right back. And so y'all can come back to me later on that. Y'all. But That's not what I mean, sir.
Okay.
Thank you.
I think you need to stop and want something else.
Mr. Rush, let me ask you something.
This is a pivotal moment in the hearing. Notice how Judge Stevens keeps returning to the same theme, accountability. He is not just looking at the new allegation. He is looking at the defendant's response to being given leniency in the first place. From the court's perspective, probation is built on trust. Once that trust is broken, especially by committing a similar offense, the conversation shifts from rehabilitation to consequences. And right now, you can feel the judge drawing that line.
I think there's an indigent form here because you just don't get free lawyers when you get in trouble. You got to pay for your lawyers, or the taxpayers. If you're unable to, if you're indigent, taxpayers have to pay, which they don't find that amusing when they work and they feel like people have to, just like them, when they get in trouble, they got to take care of their trouble. You're showing zero income. You have zero income. You don't. Well, I mean, where did you get your clothes? Goodwill. Where do you live? Do you pay anything at all? Well, see, I had family members who had strokes and they were employed. I mean, how did you get here today? Okay, but you're ambling about. You can walk. You're interacting with me. You seem intelligent. Why aren't you getting a job?
Now the focus completely changes. What started as a discussion about legal representation suddenly turns into a conversation about personal responsibility. The judge is challenging the defendant's claim of financial hardship, and you can already sense where this is headed. This is no longer just about income. It is about effort, fair or unfair. The judge wants evidence that the defendant is actively trying to improve their situation rather than simply accepting it.
You just don't blame it on. Everybody's got problems. You know, everybody's got a physical problem. You're not being, you're not being punished in any way. You know, we got good days and bad days, but all of us are imperfect. Why aren't you working somewhere? Because look at you. You look like you're healthy and you're smart.
Actually, I'm thinking to get my disability. I just got on medication. I'm pretty bad off.
What do you mean you're bad off? You're ambling about and you're speaking coherently. What's your problem?
Car wreck I got into.
Okay. Who hadn't been in a car wreck, you know?
Hospitalized like 3 times.
Sir? I know, but you're not on deathbed right now. Everybody's got problems, and sometimes people die or almost die, but they rebound. That's the way nature makes us. We're elastic almost.
This exchange is probably going to divide viewers. On one side, some people will see tough love from a judge who believes people should push through adversity whenever possible. On the other side, critics might argue that disabilities are not always visible and that outward appearances do not tell the whole story. What do you think? Is the judge motivating the defendant to regain independence? Or is he overlooking challenges that cannot be seen in a courtroom?
We can rebound. I don't understand. What are you doing about getting a job? Are you doing anything, or are you just going to take a free ride off the government money? Because I'm talking about people who are paraplegics, and I can understand that. But you're ambling. You look healthy. You speak. What can't you do?
Can't be on my feet in 130, 45 minutes.
I know there are jobs where you can sit. Look at me. I'm sitting down.
I'm literally waiting on my disability.
Is that you elected to become dependent? That's a choice.
I can't get back on the table. I can't work on table.
Why can't you work? I don't understand.
That's what I've done all my life. On table.
Well, you're gonna have to try something different that's you're able to do. But you want to be independent, don't you? Everybody, you have that. Okay. Well, I think you can be. So you had a setback. We all do. Pick yourself up, dust yourself off, and do the best you can with what you have to work with. But I don't understand why you're just saying I gave up. I'm not going to work. I'm not going to. Everybody else is going to pay my way. That's.
I don't look at it like
okay. Good. But I need you to convince me that we're not going to pay your way through this. And have you ever been in criminal trouble before?
Yes, sir. When I was 19, 40s.
Well, what? Okay, what happened at 19?
I got a head on collision. And 5 years ago.
Oh, it was manslaughter? Person died? So you're not eligible for probation in front of a jury, is what you're saying. Is that right, Langston?
Yes, sir.
He's not.
Wow. That revelation changes the context immediately. A prior manslaughter conviction is not something a court simply overlooks when evaluating sentencing options and probation eligibility. The judge is now weighing not only the current case, but also a criminal history that raises serious concerns about risk and accountability. Suddenly, this hearing has become much more complicated than it appeared at the start.
Oh, but
Yes, sir.
but this is. I mean, he's eligible for deferred.
Would you?
Well, yes, yeah. Juries don't give those.
But you can tell the judge yourself.
No. Y'all talk about it, but on the and hey, if he needs a trial on it, if he's contesting it, that's his right. We defend that. What's the loss on this? Is there a loss?
Yes, sir.
So what is this, Your Honor?
Well, I'm sorry. This is Mr. Rutz.
Right.
Reagan.
That's a missed part. Again, I'm sure.
Reagan, what you need to do is you gotta. I expect you to go out and try.
There was I'm sorry, Your Honor. I'm sorry. There was none. The ATV was recovered on it.
Okay, there's no restitution on this one. I mean, this is one that's fixable, I think. Yeah, but it's y'all's deal. If you're not guilty, you're not guilty. That's the way it is. And there are options that are available. But here, this zero across the board. Get out there and try. I expect you. Try. I think you're capable of, independence and also making a better life, not only for yourself, but.
And here comes the judge's final message. He is not demanding perfection. He is demanding proof of effort. Notice that he is giving the defendant time and asking for documentation, showing attempts to find employment. That detail matters. Courts often respond more positively to people who can demonstrate genuine effort, even if they have not achieved results yet. For weeks from now, the judge expects evidence, not excuses. The question is, will the defendant come back with progress, or will this conversation become even tougher next time?
For others, too. We'll do it. All right, I'm going to give y'all 30 days, 4 weeks, okay? On this Langston, 44 weeks, okay?
That's fine. And I think I should
come in and tell me where you are on this. And hey, Megan, I want to get someone make a note here. I want some proof of what you're doing to find employment, okay, with your circumstances.
And Judge, on Miss Murphy, I did one talk to Miss Dobbs. If you don't mind, can you please give me 4 weeks?
You got it.
And I can make it happen. But Jones was all paperwork.
Get a resetting here, Mr. Rutz, from that record. Okay, who do you have here? Jordan.
And that ending right there tells you exactly what this judge believes. Accountability doesn't stop at the courtroom door. Whether it's violating probation, assaulting a public servant twice, or refusing to even try finding work, the judge is drawing a hard line between hardship and excuses. But here's the real debate. Was this tough love meant to push these defendants toward responsibility?